Good morning. This is the House Transportation Committee. It is Thursday, May 15th, and we're continuing our discussions on legal trails. We'll have three people.
Here.
Oh, you're here.
Good morning. Sorry about that.
We have three people lined up today to talk to us on this topic. And first up is Jeff Hanford from Vermont Lead Director from the Vermont Leads Towns and Cities. So Jeff, if you want to join us, that would be great.
Screen here.
Good morning, folks.
Good morning.
Thanks for having me in. For the record, Josh Hanford. I'm the Director of Intergovernmental Relations at the Vermont League of Cities and Towns. And I have with me here colleague Kale Romanoff, who's a staff attorney with the League of Cities and Towns Municipal Assistance Center, who will take over after I give sort of a brief overview of our position on this. And Kale will address a little bit more of the legal questions that I think some folks in the committee have had throughout this discussion. So start here so I can see what is a legal trail. We've heard from a number of folks here, a number of advocacy trail user groups. A legal trail is a public right-of-way that's not a highway and that was previously was a designated town highway or a new public right-of-way laid out as a trail by the municipality legislative body to provide access to abutting properties or for recreational use. I think that's what we're talking about today. I know you've heard some testimony about this Act 178 from back in 2006. That was a process to require municipalities to map all class 1, 2, 3, and 4 town highways and legal trails by 2015. And it also discontinued a number of legal trails and class 4 roads that communities didn't want to keep. I happened to be at the Agency of Commerce and Community Development in the department that was administering this grant program at that time. I served as community development director and then commissioner of Department of Housing and Community Development. But this grant program was administered by the Community Planning Division. And I remember working with folks, communities across the state. In fact, one of your former colleagues who was a state rep and also served as a planner, Sue Minter, was involved in this project. But that effort was to do the research, identifying, planning, and mapping these ancient roads to establish whether the towns were going to officially put them on the map, keep them, or discontinue them. And at that time, that process, according to VTrans, added 248 miles of legal trails to the existing network and 148 miles of class 4 roads. I think, everyone's heard the new number that now there's, almost 550 miles of legal trails and about 90 municipalities. The grants at that time were provided to 89 municipalities to do this work. So just wanted to sort of set the stage with that information. Yeah, and ask your question.
Yeah, sure. And just to clarify, during this time, I was on the select board and I remember going through this process nobody added any right-of-ways. These were right-of-ways that were, somewhere on maps or, people knew that they existed. And it was an opportunity for the towns to sort of solidify that and say, these other ones, we don't even really care or need anymore.
Right. And that's my understanding as well at the high level. And most importantly, it was to put them on an official map so that there was no question that these were legal trails, legal roads in the municipality's jurisdiction. The protecting access to these legal trails in the public lands is critical for the state. It's critical for municipalities, state, federal partners. There's a lot of connections that these legal trails make that connect to much larger tracts of land that are publicly owned. And it's sort of, one of the backbones of our rural economy and outdoor recreation in Vermont. I'm sure you've heard the stat that, we are number 2 in the country of a GDP produced from outdoor recreation behind Hawaii. And this map over here is Rochester. And I happen to live, I don't know if you can see my cursor, but this little loop right here was Edwin's Pond Road. And this yellow highlighted area is a legal trail. And this shaded area is Riley Bostwick Wildlife Management Area. That's how people access Riley Bostwick Management Area. And then you go up on that ridge and there's a little teeny block of land up there. That is a landlocked state forest. One of the smallest state forests in Vermont, but it has a beautiful view up there. And again, legal trail is the only access point to it. And so, I show these to show how much this one legal trail is connected to state investments of wildlife management areas, forests and parks, and then across the way, that's all federal land. So there is public land that's been invested in that is critical access point or a legal trail that I'll show you later has been on the map in Rochester since the late 1800s, but it goes through many private property owners as well.
Is that the snowmobile trail too?
Part of it is a snowmobile trail in the winter,
Okay.
part of it is a mountain bike trail in the summer.
Perfect.
People walk on it, access the wildlife management area for hunting. Absolutely. It's a multi-use trail that gets a number of users, and there's a little parking spot on it. And part of it turns into a class 4 road, and then it becomes impassable, and then it's the legal trail.
Yeah.
But as I mentioned, almost 550 miles of these legal trails. Here's just a sampling of some of the miles of legal trails in some of our towns around the state. I might add that not only am I interested in this from the league as municipalities, some of these trails are beloved treasures in town. Now I live in Randolph, and there's an old carriage road that has, again, been on the maps. It's a legal trail, 100 years, and it takes you to a beautiful view atop of Braintree Hill, which overlooks the town, and people walk on it, walk their dogs all the time. But been involved in trail groups for a long time, was one of the founders of a very large trail group in central Vermont that does mountain biking and backcountry skiing, now known as Ridgeline Outdoor Collective. At the time, it was Rochester Area Sports Trails Alliance, RASTA, and really was involved in working with landowners and municipalities to allow outdoor recreation for backcountry skiing and mountain biking and walking on dozens and dozens of trails. And it's a lot of work to make those connections and keep those relationships up. And so it definitely is something that takes time and a lot of work. So we did a survey, a quick survey. I'll say only 45 municipalities responded to try to understand how municipalities currently maintain trails, for what uses, what's involved on it. Municipalities do invest public resources in maintaining legal trails, largely to do things like clear brush and trees, provide signage. Sometimes they do grading and ditching. And of the municipalities that responded, they coordinate with volunteers. Volunteers are mainly doing this work, user groups. But these trails, these on the legal trails, 70% of the respondents says they're open to bikes, 60% to snowmobiles, 40% to ATVs. And as I said, the costs are shared by municipalities, nonprofits, landowners as well, and businesses. And there's a picture there of a legal trail down in Stratton.
Vice Chair.
Oh, first, Representative White.
Just curious, thank you for this. The timing of the survey, was that recent?
This is recent. Yeah, this is just a month or two ago. Yeah, in sort of response to questions about this issue that's bubbled up. But as we said, we know there's 90 municipalities that have legal trails, and we had 45 respond to a survey we put out. Yeah, I'm almost done with a quick overview because I want to leave a lot of time for Cale to address the legal questions that are brought up. The Senate language in our view, would clarify the municipal authority to maintain legal trails. It's VLCT's position that municipalities have the exclusive authority to maintain the legal trails that are explicitly authorized to regulate. Municipal legislative bodies retain control over all municipal property through their powers under Title 24 and the general supervision of the affairs of the town. Municipalities want to permit hiking, hunting, cross-country skiing, biking, ATV use on these legal trails and would be powerless to do so if the trail falls into disrepair. You've heard it said again, it seems almost illogical to have the right to designate the use of a trail, but not be able to maintain it for that use. If you can't do that, it's the meaningless lines on a map. The other, thing to note is that 70% or more of all trails in Vermont are actually located on private land. And so it's even more important that these municipal rights of way that are just a small subset of the trail network in Vermont is important to protect. And as I showed on some earlier maps, they access some of our state investments of our own public dollars for recreation of all sorts. One last slide for me, just this same current map that I showed you in 24 with Riley Bostwick Wildlife Management Area, Cushman State Forest, another big forest. This same legal trail and Class 4 road on the maps in Rochester goes back to 1869. And here it again is in 1941 and 2004. So there's a long history with some of these legal trails and Class 4 roads that are very important to communities and the residents of town. And I think as Cale, the municipal assistance attorney, will explain, the residents value these trails. And if we were to lose access from them, there would be a demand to seek those, to regain those access points. And so our position is whatever concerns they may be for new litigation, if you make the decision now, which we encourage you to do, to put this language in, make it effective immediately, we will deal with those consequences because we believe that the risks are greater by having the threat of these removed and the municipalities asking to take ownership of them through whatever means necessary. And so that's a very non-legal way of sort of saying what our position on is about the concerns of lawsuits to municipalities if you go forward with this language. So I will stop there and let Cale come up and do his part, and I'll move through a few slides. You're ready.
Sounds good. Thanks, Josh. Thanks, committee. Thanks for having me. My name is Cale Romanoff. I'm an attorney with VLCT's Municipal Assistance Center, where myself and 3 other attorneys help municipal, that's a tongue twister, where we help municipal officials by answering their questions concerning general municipal law, local government management and administration, and how to apply legal requirements to the day-to-day governance of their operations. These frequently include issues related to highways, trails, or public rights of way. And you've heard from my colleague Josh and some other witnesses about the policy and background reasons for this bill. I'm going to cover kind of the elephant in the room here a little bit more with my discussion today, and that's the threat of an inverse condemnation or a takings as a result of this bill if the petitioner in Tunbridge happens to be successful. Myself and my fellow attorneys at the Municipal Assistance Center, we think the risk of a takings claim against the municipality is quite low if this trail language is included. And we think that for a couple of reasons. First, and primarily, is that we don't think it's going to get there. It has been the long-standing, generally accepted, conventional legal wisdom, and I'm using those words purposefully. The towns do have the right to maintain their trails. Petitioner in Tunbridge, he highlighted that there is no explicit municipal authority for maintenance on legal trails in Vermont statute, and that's really what brought us here today. However, they highlight the lack of clarity and not a lack of authority. And that's because of Dillon's rule, if you want to switch the slide. Dillon's rule, which really guides all municipal action in the state, they can only do what you and the legislature have told them they can do. Dillon's rule is not so rigid as to require the legislature to explicitly spell out each and every single potential authority that might come along with their roles, responsibilities, and duties and their other authorities. And it accounts for these additional functions that may be, quote, incident, subordinate, or necessary to the exercise, unquote, of those explicit authorities. And as you see, that has been spelled out by the Vermont Supreme Court. We think maintenance authority for legal trails is clearly, necessarily implied and or incident to multiple grants of authority already in state statute. If you want to move to the next slide, the first one is not an explicit grant of authority, but it kind of highlights the implied or incident or necessary prong of Dillon's role. In common law, well, let me step back a little bit. Legal trails in Vermont statute are defined as public rights of way. The law does not define a public right of way for us, so we will look to the common meeting, and according to Black's Law, quote, a Black's Law dictionary, quote, a public right of way is defined as the right of passage held by the public in general to travel on roads, freeways, and other thoroughfares. And this is akin to an easement in the traditional sense for ingress and egress, and as you've seen and through some other statutory provisions previously in other testimony, likely recreation as well. And maintenance rights, they are of course necessary to preserve that intended use, the intended use of that easement in common law. And it is the holder of the dominant easement, in this case, the town, the holder of the public right of way. They are generally entitled to use that easement, quote, in a manner that is reasonably necessary for the convenient enjoyment of the servitude. And that, quote, also comes from the Vermont Supreme Court. And they are quoting themselves the restatement of third properties, which I have posted here on the slide. So as a public right of way, it is implied that the holder of that easement, the easement holder, in this case, the town, the municipality, that they have the authority to maintain it for its designated public use, whatever that use may be. Now onto the explicit authorities, if you want to kick the slide. I believe some of these have been covered in previous testimony as well. The legislature has conferred on the towns the authority to regulate the use of their trails. That is 19 VSA 304A5, where it says the duties of the select board involve granting permission to enclose pent roads, trails by the owner of the land during any part of the year by erecting stiles, unlock gates and bars in places designated, and to make regulations governing the use of pent roads and trails. This authority has been repeatedly recognized by the legislature as well to allow municipalities further to open their legal trails to all-terrain vehicles. That is found in 24 VSA 3506, to snowmobiles. That is found in 23 VSA 3206, and to e-bikes, which is in 23 VSA 1136A. So if you can regulate the use of trails, whether for ATVs, snowmobiles, e-bikes, or other recreational activities, it is necessary to be able to maintain them for those uses. In contrast, if the towns were to open their trails to use by ATVs, snowmobiles, and others, that authority would effectively be useless if they could not then maintain it when they fall into disrepair. If that were the case, the municipal regulatory authority on trails would really be illusory once that trail is no longer passable. The second clear explicit grant of authority is the legislature conferred the authority to lay out new trails for both access or recreational use. You want to kick that slide? That's 19 VSA 301. And it states that a trail means a public right of way that is not a highway, as we've discussed. And that is, I'm not going to cover the A section that's relevant here, but in B, a new public right of way laid out as a trail by the select board for the purpose of providing access to abutting properties or for recreational use. So the question that raises the question, if you can lay out a new trail for access or recreation, then maintenance is necessary to effectuate that public use. Or again, the authority is illusory. So maintenance is an applied authority to each of these express grants, and furthermore to these express grants, the legislature also expressly exempted towns from the liability for maintenance of their trails. If you want to take the slide, you'll find that in 19 VSA 310, where it says, quote, "A town shall not be liable for construction, maintenance, repair, or safety of trails," unquote. Then it raises the question, why would the legislature need to exempt the town from liability for maintenance of its trails if they're not authorized to perform that maintenance? It just simply makes the authority discretionary. Let me step back. We believe this language purely makes the maintenance authority discretionary. It's not that it makes it non-existent. So it's PLT's legal opinion that the authority to maintain exists currently and that authority has historically been relied upon. And these statutory changes will codify that existing interpretation, the general practice throughout the state, affirming that towns can maintain their legal trails for their intended uses. And it will provide the certainty that municipalities and recreation groups are seeking at this moment. Now, secondly, go ahead with the question.
Just another question on 19 VSA 310.
Yep.
What was the date of that? Was that the 1985 or was that the?
That I don't know, but I can quickly pull up the link and tell you when the last amendment was. It was amended and added in 85, amended in 99, and again in 2000. Now, our second point on this, which was a little bit harder for us to come to because it's hard to explain against something that we don't think is going to result in the whole takings issue. But we wanted to go through the exercise just to kind of give you a little bit more clarity on what might happen if the court were to side with the petitioner and rule that the landowners in fact hold the interest in the underlying property. Landowners who hold the interest in the underlying property have the exclusive right to maintain those trails. And it's not as clear as it may have been described to you all that municipalities that will rely on this provision would be subject to a takings claim for that maintenance. Now, keep in mind, legal trails are either downgraded former town highways or a trail that has been laid out by the select board. In either case, the town had condemnation authority and there was an appeal process for impacted landowners throughout the process of laying out the new highway. And that can result in damages made to the owners through which the highway passes. And that process, for your reference, can be found in 19 VSA section 708. It's a pretty thorough process, whether you're laying out a new road or downgrading or upgrading it from a previous designation. But this is all to point out that if there's a legal trail running through or abutting your property, a landowner or a predecessor in interest either assented to or was compensated for that public right-of-way during the process of laying out the trail or the highway that preceded it. The property owner then purchased the property subject to this existing right-of-way, and any case involving a town performing maintenance in that right-of-way then will focus solely on the damages caused by the maintenance. This is the singular stick of rights at issue here. No question about the scope, the width of the right-of-way, the public's interest in it. It's purely about whether they can maintain it. So we're looking at a narrow avenue for any sort of claim.
Just have a quick question.
Is this the place for me to ask a question? Or
Sure.
I just want to clarify. So if, however way the case goes, the trail is still open to anybody.
Still public right-of-way.
It's still public right of way for hunting, for anything. It's only the maintenance.
Correct.
Okay.
Now, I mean, the select board would have authority with their regulatory authority to put some bounds on what the public can do in that right-of-way.
I mean, would they
But they-
ever say no bicycles or no ATVs or, they could, the
They could.
town could do that,
Yep.
even if the maintenance authority goes to the landowner.
Yeah, they could allow bikes, but they wouldn't be able to maintain it. So at some point it would potentially be unusable.
I see. So somebody would go to the town and say, I want to use this trail for my bike ride.
They could permit it.
Or for, for hunting or whatever. And the town would say, fine, but the landowner wouldn't have maintained it enough for it to be.
Correct. They could refuse to maintain and it would fall into disrepair.
Thank you very much.
Yep.
Sort of like we did with the rail trail language in our table.
Yeah.
Yeah, Representative Thompson.
Yes, thanks for this testimony.
Mhm.
Can you tell me, have there been other cases like, where a landowner who has a right of way road, class 4 road or trail that's, claim to have maybe more ownership than what we think they have?
Not to my knowledge, within the right of way. I am aware of some cases involving snow throw, snow over the property line. And actually had a quick mention of that in my last paragraph here, in fact. But that's not quite analogous because it's outside of the right of way. But as you see from my quote, it kind of fits to an extent here. Let me finish my last sentence, or paragraph, I should say. The purpose of the takings clause is, and I'll quote here from the US Supreme Court, is to, quote, bar government from forcing some people alone to bear public burdens, which in all fairness and justice should be borne by the public as a whole, unquote. But it's unclear, in our opinion, if the petitioner is successful in this case, whether a municipality improperly maintaining its legal trails is forcing the landowner who holds that underlying interest in the right of way to bear any burden, since this really is a public right of way to which the landowner has been compensated or otherwise assented. And the determination of burden, of course, is going to depend somewhat on the level of maintenance. And we think for general trail work, though, this is unlikely to be significant and is probably going to be more likely to be resolved with an injunction commanding the municipality to stop maintenance rather than a takings clause. But again, this is pure speculation. We have a lot of what ifs and down the line, but that's the way we have been looking at it from our end. Of course, larger maintenance projects may be more subject to a burden and more subject to a takings, but again, that's unclear. I think the key piece I wanted to point out to you from this case I was just mentioning, though, is that the Vermont Supreme Court has repeatedly ruled that speculative damages are not compensable in an inverse condemnation case. And an inverse condemnation case is when a regulatory action serves to take property interest from this person. So that would be in this type of case.
You got another question now, Representative Lau?
Yeah, I'm wondering, I assume at some point this was a class 4 road and it became a trail.
Likely.
Yeah, just, how many rods wide is this trail?
I don't know the trail in this case at question. The general rule of thumb is 3 rods
Yes.
unless there is evidence to the contrary.
And does the town of Tunbridge have zoning regulations?
That I'm not sure.
Yeah,
You'd have to ask Tunbridge that.
because, frontage rules would then apply if there is, if the right of way is still, anyway, I am wondering about the possibility for a class 4 trail to, a trail to become a class 4, upgraded to a class 4 road, or even a class 3 road. And, we're making assumptions that these are going to be staying in this condition. And I thought that some of the purpose of having an easement and having these easements put on maps was to provide the municipality with future ability to, determine whatever the future vision of growth is, or obviously according to a municipal plan and things like that. So this just, I'm just sort of stuck on that, and I'm assuming that's beyond the, this case and not germane, but it's the way I've been sort of looking at it.
Yeah, and I think that's some of the, I'm speculating here, but I think that's some of the purpose for why during this ancient roads process that some towns held on to the trails, even if they didn't have a clear need for them at the moment. They don't know what the future is going to hold. Provides them with options going forward. But it kind of lends into my final point in that I think if this language is added and the petitioner is successful, I think if the language is not added and the petitioner is successful, I think the towns are likely to use this a ruling to this effect to reclassify their trails. They're either going to reclassify them up to a 4, or they're going to discontinue them without a maintenance authority. What is a public right of way without maintenance authority? It's really just lines on a map. So the towns are going to presumably take this opportunity to go up or down with their trails because they're arguably meaningless without authority. And that is all I had for today. And if you guys have any further questions?
Representative Keeler?
Where are we in the legal process?
To my understanding, it is in the Superior Court summary judgment.
Okay. And so the process from there would be that, and correct me if I'm wrong, that if you got a summary judgment in favor of doesn't matter, you'd still have an appeal to the Supreme Court?
I think it's appeal to the Supreme Court seems likely in this case on either side, I would suspect.
So is there any matters of law after any ruling from the Supreme Court? Can you imagine? In other words, could you go from, I understand that the case, the facts in the law, in this case, there's also facts outside the case, which is the reverse condemnation part of it. He can go back or the plaintiff could go back and retry it through that process.
I think that's the fear posed by Ledge Counsel if he were to be successful, is then he might try to come back and argue inverse condemnation and seek damages for
So that process may take another 3 years.
Just a good guess. His guess is good. Might take longer. If the ruling goes in favor of the municipalities, though, there really isn't an avenue for that argument.
There isn't. Okay.
No, because then it's clear that the towns have the authority to maintain, so you can't claim that you took that authority away from me because the towns have it.
So there's no legal
The,
basis.
the, the takings argument really is if the petitioner were to be successful and win his suit against the
Okay,
town of
thank you.
Tunbridge.
Representative Cox?
Yeah, I'm gonna go on a limb here and say, it appears the majority of legislators, would not want to see trails be threatened in this way, to not be able to maintain them. And I may have asked this question to another witness, but if we add this language, this or something very similar to this bill, is there any additional threat, to point, hey, because the legislature did this, they must be aware that they're in trouble and, trying to prevent this. So
I think a clear purpose statement would address that, to note that you are adding this language to clarify existing law, to put it out to the court if it were ever to be considered in that manner, to put it out that this is why you're doing it, not because you are realizing it didn't exist. You're doing it because you think it exists and you're just clarifying the law.
Yeah, okay. All right, thanks.
Any more questions? If not, thank you very much.
Thank you guys for having me. Thank
That
you.
was handy.
We have a little time. The next person to come in is actually the landowner at 10 o'clock. Yeah, I guess we can go up live and